Yes, Mr. Freeman, we're just waiting for them to put the jail on.
Yes, Judge, thank you.
No problem.
That's good.
Can you hear me in the jail?
Yes, ma'am, we can hear you. Are we coming through okay?
Yes, you are. Okay, on the record in the matter of the people of the state of Michigan versus David Williman, file number 23-03321 FY, counsel appearance.
All of it from the table, it's just easy for them to see in the courtroom. Thank you, sir.
You are muted, Mr. O'Keefe.
Yes, I'm sorry. Good afternoon, Your Honor. Patrick O'Keefe on behalf of Mr. Williman.
Okay, and are you David Williman?
Yes, Your Honor.
Okay, Mr. Williman, today's the date and time set for an arraignment. I have a felony complaint that alleges that on or about December 18th, 2018, at the area of 812 East Jolly Road, which is located in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of criminal sexual conduct in the 4th degree, mental health professional. It alleges that you did, being a mental health professional, engage in sexual conduct with a Luann Nichols while the victim was a defendant's client or patient, or within 2 years after the period in which the victim was the defendant's client or patient, and this was done contrary to Michigan Compiled Law 750.520E1E. There's a Sex Offender Registration Act notice. It says this is a tier 1 offense under the Sex Offender Registration Act if the victim is 18 years or older, under Michigan Compiled Law 28.722R5. If is a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It is a tier 2 offense if the victim was between the ages of 13 to 17 inclusive. And it is a tier 3 offense if the victim was under 13 years and the defendant was 17 or older. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. There's an HIV STD testing notice. It says take notice that pursuant to Michigan Compiled Law 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is a reason to believe the violation involves sexual penetration or exposure to a body fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. This is a high court misdemeanor. Maximum penalty is 2 years and or $500 in fines, and there's a mandatory HIV STD testing requirement, and your DNA is to be taken upon arrest. Do you understand the charge that was read and the maximum penalty attached, sir?
Yes, Your Honor.
You have the right to be represented by counsel, and you have representation by way of Mr. Patrick O'Keefe for the purposes of your arraignment. Have you retained Mr. O'Keefe to represent you throughout the pendency of this matter, or is that your intention?
I have retained him, Your Honor.
Okay, so you have retained counsel, but I'll still advise you of your right to counsel, and that is that if you could not afford to hire an attorney, you can make a request to have the public defender's office represented at the expense of the public. I will note here that you are declining the public defender's office at this time, and you've retained Mr. O'Keefe. Okay, and Mr. Williman, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, this matter will proceed all the way to your jury trial. You have the right in this matter to a preliminary examination prior to jury trial, and that's because it's a high court misdemeanor. You have the right to have the preliminary examination within 21 days of the date of your arraignment. At the time of your preliminary examination, you have the right to require the prosecutor to establish the minimum burden of probable cause. So they need to establish that they have sufficient probable cause that a crime was committed and a probable cause sufficient to charge you with that crime. You have the right to proceed to a trial, and you have the right to jury trial. You enjoy the presumption of innocence, sir, so you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront in court and cross-examine any of the witnesses that the prosecutor intends to call against you. You have the right to call your own witnesses to your trial or present evidence at trial that you believe further defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. Do you have any questions about those rights?
No, Your Honor.
Thank you. For the purposes of his arraignment, is he pleading not guilty, counsel?
That's correct, Your Honor.
Okay, Mr. Willerman, are you still employed at CMH?
I am not, Your Honor.
Where are you employed now?
I'm self-employed.
You're self-employed doing what?
I do land work.
And what's your home address?
4773 Ardmore Avenue, Ardmore. And that's Okemos, Michigan, 48864.
Your phone number?
989-898-8358.
You're currently scheduled for probable cause conference before Judge Tony Flores on Thursday, December 7th, 2023 at 9 o'clock in the morning. You have a preliminary examination before Judge Flores Thursday, December 14th at 9 o'clock in the morning. You can appear to your probable cause conference via Zoom. You just need to have video. You can't be doing anything that's distracting to a court proceeding. And then you also have your preliminary examination, but that is in person at the court, okay?
Yes, Your Honor.
Did you get your notice to appear for those dates?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Have you missed court in the past?
No, Your Honor.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Willerman came to me last week, and he advised me that he had just been informed that he was being charged with this offense. So we made arrangements for him to turn himself in today, which he did on his own accord. So based on that and the fact that he lives in Okemos, Your Honor, he's got stable ties to the community. He's invested in his defense. I don't believe there's any indication that he's ever failed to appear for court. With respect to the alleged victim, I don't believe that there's any sort of relationship there. I don't believe there'll be any issues with him abiding by the court's no contact provisions. So I don't believe that there's a danger to any other person in the community. This allegation stems from an alleged incident that happened, I believe, almost 5 years ago now. As Mr. Willerman indicated, he is no longer employed with CMH, and he no longer carries a license with the state of Michigan to provide such care. So again, I don't believe that there's any indication that there's a danger of him reoffending or a danger of him offending against any other person in the community. Therefore, I would ask the court to consider a PR bond, and the alternative, I would ask the court to consider a low, like a 10%, $5,000, 10% bond.
I reviewed the defendant's prior criminal history, and as indicated by you, Mr. O'Keefe, this is a matter that allegedly occurred in 2018. I don't believe that there is an immediate threat to the public safety. He has invested in his defense by retaining counsel and turning himself in on the warrant. For that reason, the court will grant a personal recognizance bond. Bond will be set in the amount of 10,000 personal recognizance with the following conditions. You're not to have contact direct or indirectly with Luann Nichols. Do you understand that?
Yes, Your Honor.
You're not to travel outside the state without getting approval from the court in advance. You are not to engage in any assaultive or threatening behavior. You're not to purchase or possess alcohol or drugs without a prescription. You're not to purchase or possess a firearm or any other dangerous weapon. You're not to assault, harass, intimidate, beat, molest, wound, or threaten Luann Nichols, and you're not to cause any contact either directly or indirectly to be made to Luann Nichols. You're not to be within 2,000 feet of wherever she is. Do you understand that?
Yes, Your Honor.
Do you have any questions about your bond conditions?
No, Your Honor.
You need to report to pretrial services within 48 hours of your release from custody, okay?
Yes, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you for stepping in for this arraignment. We appreciate it.
No problem, you're all set.
Thank you.
On the record in the matter of the people of the state of Michigan versus Naresh Kasi Reddy, file number 23-03575, counsel appearance.
I'll put it on.
Mr. Freeman, you're muted. You have to unmute first. Mr. Freeman, your computer is muted. You need to unmute it.
I'm terribly sorry.
Have your appearance, please.
Yes, Your Honor. Stephen A. Freeman, Assistant Public Defender on behalf of defendant for arraignment.
Okay, are you Mr. Kasi ready?
Yes, Your Honor.
Okay, Mr. Kasi ready. I have a felony complaint here that you're going to be arraigned on. The allegations are that on or about November 27, 2023, at the area of Morgan Lane and East Michigan Avenue, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of child sexually abusive activity. The allegations is that you did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity, and that this was done contrary to Michigan Compiled Law 750.145 C2A. There's a Sex Offender Registration Act notice. It says this is a tier 2 offense under the Sex Offender Registration Act. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. This is a felony. The maximum penalty, 20 years imprisoned and or $100,000 in fines. There's a count 2 of computers using to commit a crime, maximum imprisonment of 20 years or more, or life. It alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive activity, contrary to Michigan Compiled Law 750.145C2. This is also contrary to MCL 752.796 and contrary to MCL 752.79734. That's a felony with the maximum penalty being 20 years in prison and or $20,000 in fines and reimbursement to the government for expenses incurred in relation to the violation in a manner indicated by MCL 769.1F. And a consecutive sentence may be imposed for the underlying conviction. There's a count 3 of children accosting for immoral purposes. It alleges that you did accost, entice, or solicit an individual who you believed was a child less than 16 years of age with the intent to induce or force that individual to commit an immoral act, to submit to an act of sexual intercourse or an act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts, and that this was done contrary to Michigan Compiled Law 750.145A. There's an HIV STD testing notice. It says, take notice that pursuant to Michigan Compiled Law 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is a reason to believe the violation involves sexual penetration or exposure to a body fluid of the defendant. If the district court judge determines that testing is not required upon conviction, the court must order the defendant to be tested. There's a Sex Offender Registration Act notice attached to count 3. It says this is a tier 2 offense under the Sex Offender Registration Act. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 3 is a felony with the maximum penalty 4 years and or $4,000 in fines is the sentence. There's a count 4 of computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. The allegation in count 4 is that you did use a computer program, computer system, or a computer network to commit, attempt to commit, conspire to commit, or solicit another to commit children accosting for immoral purposes under MCL 750.145A-A. This was contrary to Michigan Compiled Law 752.796 and Michigan Compiled Law 752.7973D. Count 4 is a felony, maximum penalty 7 years in prison and or $5,000 in fines and reimbursement for expenses to the government for expenses incurred in relation to violation in manner indicated under MCL 769.1F, and a consecutive sentence may be imposed for the underlying conviction. Do you understand the charge and the maximum penalties attached?
Yes, Your Honor.
You have the right to be represented by counsel. You're represented today by Mr. Freeman from the Office of the Public Defender. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution. You have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, but you economically qualify, you can make a request to have the Public Defender's Office appointed at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, the matter will proceed all the way through to a jury trial. You have the right in this matter to have a preliminary examination. You have the right to have that examination within 21 days of today's date being the date of your arraignment. At the time of your preliminary examination, you have the right to require the prosecution to meet their burden of probable cause. So they need to establish sufficient facts that there's probable cause that a crime was committed and probable cause to charge you with the crime. Do you understand your rights so far? Do you understand your rights so far?
Yes, Your Honor.
Okay, so again, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right, if this matter proceeds to a trial, to the presumption of innocence. So you are innocent until proven guilty. You have the right to require the prosecution to prove your guilt at a trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have the silence be used to prove or imply that you're guilty. You have the right to confront in court any of your accusers and to cross-examine or question them. You have the right to call your own witnesses to testify on your behalf at your trial. You have the right to present evidence at trial that you believe would show a defense to the charge being brought against you, or the charges being brought against you. Do you have any questions about those rights?
No, Your Honor.
Is he requesting court-appointed counsel?
The gentleman did, Your Honor, yes.
Okay, for the purposes of your arraignment, sir, we're going to enter a plea of not guilty on your behalf. Are you currently employed?
Yes, Your Honor.
Where are you employed?
Resource Point, Troy.
You said Resource Coin?
Yes, Your Honor.
What's your home address?
2359 Fieldstone Drive, Okemos, Michigan 48864.
What's your phone number?
815-508-2467.
Repeat that for me again.
815-508-2467.
You're currently scheduled for probable cause conference before Judge Stacia Buchanan, Thursday, December 7th at 8:30 in the morning. You have a preliminary examination before Judge Buchanan, Thursday, December 14th at 9:30. Did you get your notice to appear?
Yes, Your Honor.
You may appear for your probable cause conference via Zoom, but you must appear in person for your preliminary examination.
Okay, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Do you have any other matters pending in any other courts?
No, Your Honor.
Have you ever missed court in the past?
No, Your Honor.
Counsel, you can address bond.
Yes, Your Honor, thank you very much. Mr. Casilla and I both recognize that the charges now pending are very serious. And I indicated him earlier when I spoke to him that this court would be terribly concerned as to him appearing in court when ordered. I can only respond that he is a married man. He does own his home, that on Fieldstone Drive in Okemos. He's married. He has a small child at home that he and his wife are responsible for. My understanding is that the gentleman is the sole source of income for his family, and the severity of the charges notwithstanding, I would respectfully, on behalf of my client, ask the court to at least consider the PR bond with the appropriate terms and conditions to assure the court not only that he will reappear, but that the public in general would not be in jeopardy. Thank you very much.
Thank you. Okay, count one and count two being felonies with maximum penalties of 20 years in prison are being the most serious, just in and of itself, do present a concern for the court as it relates to the safety of the community. And so I will not issue a personal recognizance bond for that purpose. A bond will be set in the amount of $20,000 cash surety. While out on bond, you have the following conditions. You need to appear in court for all of your future court dates. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to travel out the state without prior approval of the court. Not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. You'll be reporting weekly. You have any questions?
Question, Your Honor. I have my phone with the officer that has taken me. All my work related security pins are in that phone. Can I get my phone back?
I don't have your phone and I can't order it back. It probably was seized as evidence. But you'll ask your attorney to look into that. I have no idea what happened to your phone, sir. But by nature of one of your charges, which is computers using to commit a crime, in count two, and then there was another count four, the same. The allegations is that you used a computer or computer system or computer networking system allegedly to solicit or conspire to commit accosting for immoral purposes a minor. And so it's likely that's why your phone was taken. I don't know. I have no more information than what was provided me today to make sure I do this arraignment for you. So as it relates to whether or not you'll be getting your phone back or how soon you'll be getting it back, that's a job for your attorney, not for the court, okay?
Yeah.
Do you have any other questions?
Oh, Your Honor.
Okay. Any additional matters for the record, counsel?
Only one, Your Honor. May I please have the docket number for this file?
Yes, that's 23-03575.
Thank you very much. Nothing else.
Thank you. You're all set, sir.
Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Wade Smith, file number 23-03577FY. Counsel appearance.
Good afternoon, Your Honor. Stephen A. Freeman, public defender, appearing for arraignment on behalf of defendant.
You're Wade Glenn Smith.
Yes, Your Honor.
Okay, I have a felony complaint here, Mr. Smith, that alleges that on or about November 27, 2023, at the area of 3301 West Michigan Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count one of child sexually abusive activity. The allegations are that you did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity, and that this was contrary to the Michigan Compiled Law 750.145C2A. There's a Sex Offender Registration Act notice. It says take notice. This is a tier 2 offense under the Sex Offender Registration Act. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. It's a felony with the maximum penalty being 20 years in prison and or $100,000 in fines. There's a count 2 of computers, internet, communicating with another to commit crime, maximum imprisonment of 15 years or more, or life. The allegation, sir, is that you did use the internet to communicate with a minor, initials KD, for the purposes of committing child sexually abusive activity, contrary to Michigan Compiled Law 750.1452C, where the victim or intended victim was believed by the defendant to be a minor, contrary to Michigan Compiled Law 750.145D2F. There's a Sex Offender Registration Act notice. It says this is a Tier 2 offense. Under the Sex Offender Registration Act notice, if the underlying offense is a violation of MCL 750.145A or 750.145C. It is a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense under MCL 28.722 TNU. This is a felony with the maximum penalty being 20 years in prison and or $20,000 in fines, reimbursement to the government for expenses incurred in relation to the violation may be ordered in a manner indicated by MCL 769.1F. A consecutive sentence may be imposed for a conviction on the underlying offense. There's a count 3. Children accosting for moral or immoral purposes. It alleges that you did, accost, entice, solicit an individual who you believed was a child less than 16 years of age with the intent to induce or force that individual to commit an immoral act, to submit to an act of sexual intercourse, or an act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts, contrary to MCL 750.145A. There's a HIV STD testing notice. It states, takes notice that pursuant to MCL 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, or for the presence of HIV or an antibody to HIV if the judge determines there's a reason to believe that the violation involves sexual penetration or exposure to a bodily fluid of the defendant. If the district court determines that testing is not required upon conviction, the court must order the defendant to be tested. There's a Sex Offender Registration Act notice again that says this is a Tier 2 offense under the Sex Offender Registration Act. It's a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Count 3 is a felony, maximum penalty 4 years and or $4,000. Count 4, computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. The allegations are that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit accosting a minor for an immoral purpose under MCL 750.145A-A. And that this was contrary to the Michigan Compiled Law 752.796 and Michigan Compiled Law 752.7973D. This is a felony, maximum penalty 7 years in prison and or $5,000 in fines. Reimbursement may be ordered to the government for expenses incurred in relation to violation in manner indicated under MCL 769.1F. A consecutive sentence may be imposed for the underlying conviction. Lastly, there's a count 5 weapons, felony firearm, alleging that you did carry or have on your person in possession a firearm, that being a black 9mm Ruger handgun at the time that you committed or attempted to commit the felony, that being child sexually abusive activity under MCL 750.145C, and that this was contrary to MCL 750.227B. Count 5 is a felony, maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There's a mandatory forfeiture of the weapon or device required under the law. Mr. Smith, do you understand counts 1 through 5 and the maximum penalty attached to each?
Your Honor.
Can you speak up so we can hear you?
Yes, Your Honor.
Okay, very good. Okay, you have the right to be represented by an attorney. Mr. Freeman from the Office of the Public Defender is here to represent you for the purposes of your arraignment only. But you have the right to have an attorney represent you at each stage of your criminal prosecution at all of your court appearances, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire your own attorney to represent you, you can make a request to have the public defender's office represent you at the expense of the public. You understand your right to counsel?
Yes, Your Honor.
Is he requesting court-appointed counsel?
Yes, Your Honor. Thank you.
Okay. Mr. Smith, you have the right to remain silent. Anything that you say and anything that you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. You have the right to proceed in this matter to a preliminary examination because you are being charged in this matter with 5 felonies. You have the right to have preliminary examination within 21 days of today's date being the date of your arraignment. At the time of your preliminary examination, you have the right to require the prosecution to meet their burden of establishing that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with these crimes. Do you understand your right so far?
Yes, Your Honor.
You have the right to proceed to trial. You have the right to jury trial. You have the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court and cross-examine any witness the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at your trial you believe further a defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used to prove or imply that you're guilty. Do you have any questions about any of those rights?
No, Your Honor.
For the purposes of his arraignment, is he pleading not guilty?
Yes, Your Honor. Thank you.
Thank you. Okay, you're currently scheduled for a probable cause conference before Judge Stacia Buchanan, Thursday, December 7th at 8:30 in the morning. You have a preliminary examination before Judge Cannon, Thursday, December 14th at 9:30 in the morning. You may appear to your preliminary examination. You must appear to your preliminary examination in person, but your probable cause conference, you may appear via Zoom. Did you get your notice to appear?
Yes, Your Honor.
Are you currently on probation or parole?
No, I'm not, Your Honor.
Are you employed?
Yes, I am.
Are you still employed as a security chief?
Yes, Your Honor.
What's your home address?
12767 West M21, Fowler, Michigan, 48835.
What's your phone number?
989-383-0062.
And do you have any questions for the court right now?
No, Your Honor.
Counsel, you can address bond.
Thank you again, Your Honor. Obviously, the charges now pending against Mr. Smith are significant. I indicated to him earlier that it was not likely the court would entertain a motion for a personal recognizance bond. On the other hand, it is true that he is a homeowner. And while it's true he is separated from his wife, they do have a child in common that he is responsible for approximately 50% of the time. So I would, on behalf of my client, ask the court to consider a moderate 10% bond, if that would please the court. Thank you.
Count one. Child sexually abuses activity felony, maximum penalty being 20 years and or $100,000 in fines. Is a relatively serious and concerning offense. Then there's also a count 5 here, felony firearm being alleged. The court is concerned based on the factors presented that there is a threat or potential threat to the community. And so the court will grant a bond appropriate to secure both the appearance in court and safety to the community. Bond will be set in the amount of $20,000 cash surety. While out on bond, you have the following conditions. You're not to possess a firearm or any other dangerous weapon. Do you understand that?
True.
Is that a yes?
Yes, Your Honor.
Okay, very good. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without seeking prior approval from the court. Do you have any questions about your bond condition so far?
Your Honor.
You need to report to pretrial services within 48 hours of your release, and you'll be reporting to them weekly, okay?
Yes, Your Honor.
Matters at 2.
Any additional matters for the record?
Only if I might please inquire of the docket number again, Your Honor, please.
3-03577FY.
Thank you. Nothing further.
Thank you. You're all set, sir. Judge Flores finished over there.
May I address the court?
Yeah, we're not on the record or anything at this point, but yes.
Thank you, Judge. As respectfully as I can, it would assist me greatly, please, if you could alert me to the name of the defendant first, and then I can pull that file, and I won't have to keep asking you to repeat docket numbers and the like. Thank you.
That's no problem. They gave me a nice little jail arraignment list. Maybe they should give that to the public defenders too. I go right down that list.
I see. Yeah, I have no such list, but thank you.
Oh, I'll make that a suggestion so that they send you that list as well. Okay, sir? I actually have a court full of people because I was filling in for the magistrate in her absence. I believe Judge Flores is going to continue their arraignments in just a moment.
Oh, all right. Very good.
On the record, in the matter of the people of the city of Lansing versus Carol Vandemore, file number 23-00271, council appearance.
Public Defender John Lee appearing on behalf of Carol Moore, who is in the courtroom and standing to my right.
Okay, Ms. Vandemore, how are you today?
Thank you.
Today's the date and the time that's set for a hearing on a probation violation that you were previously arraigned on. And the violation alleges that you committed the following technical probation violations. Per SoberLink, you had a positive blood alcohol test on October 14th of 0.052, and on November 1st of 0.039. And per SoberLink, you failed to retest on the following or following the positive blood alcohol test on the 1st. Okay, if the jail could log into Judge Flores, he's going to continue the remaining arraignments.
Thank you, ma'am.
Thank you. And so you have the right to have a contested hearing. Did she want to continue to hearing today?
No, we are not going there.
Okay, so she wants to enter a guilty plea to the violations.
Yeah, sure.
That's accurate, Ms. Vandermoor? Please raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you can put your hand down there. And so you understand your right to have a contested hearing? You understand that if you're found to be in violation of your probation, or if you plead guilty to your violation, that your your probation status can be revoked?
Yes, ma'am.
You understand that it could be extended, it could be continued, and you can still be sentenced to serve a term of jail time for the violation.
Yes, Your Honor.
You understand that other programming could be added to your probation status?
Yes.
Okay. Anybody threatening you to get you to waive your hearing? Has anybody promised anything to you if you waive your hearing?
No, Your Honor.
Do you want to plead guilty freely and voluntarily?
Yes.
Okay, as to violation from October 14th, the blood alcohol level of 0.052 per SoberLink, how do you plead?
Guilty.
And as to the violation that you tested positive with your SoberLink on November 1st, 2023 with a 0.039, how do you plead?
Guilty, Your Honor.
And then lastly, as to the violation that you failed to retest following the positive blood alcohol test on the 1st of November, how do you plead?
Guilty.
Factual basis, Mr. Lee?
Thank you, Your Honor. Ms. Vandermoor, on or about June 12th, 2023, were you sentenced to a term of probation after being convicted or pleading guilty to operating while intoxicated in case number 23-00271?
Yes, sir.
And as part of that probation, you were ordered to refrain from alcohol use, correct?
Yes, sir.
And do you deny that on October 14th, you had a SCRAM test that was positive? I'm sorry, a SoberLink test that was positive for alcohol?
No.
Do you deny that on November 1st, you had a SoberLink test that was also positive for alcohol?
No, sir.
No further questions, ma'am.
The court is satisfied with the factual basis. I'll accept your plea to the violations, and I find your plea to be made freely, voluntarily, and intelligently. The probation gave a recommendation indicating that your overall attitude is fair as opposed to good, acceptance of responsibility, fair as opposed to good, overall progress, poor. Says the defendant appears to continue to consume alcohol and requires 24/7 alcohol monitoring. And they're suggesting a scram tether as to the SoberLink for the next 90 days. 24 hours of community service to be completed within 60 days. I'm leaning more towards jail time, but I'll let your attorney make a statement.
Honor, we appreciate the opportunity to be heard. We ask that the court consider that Ms. Vandermoor is a mother of three who is obviously struggling with alcohol. She recognizes the issue. She has been proactive, recently contacting her primary care physician. She has an appointment on December 6th. The purpose of that appointment is to get a referral for psychiatric help. She believes that some of her mental health issues may be contributing to her struggle. So we're asking the court to allow her to pursue that. Certainly understand that the court may institute scram tether or community service. We believe that is entirely reasonable. And we understand the court consideration of jail as well. We would just ask that the court at this time allow her an opportunity to pursue the mental health aspect of this and give her an opportunity to continue to fight the struggle that she admits and understands.
Thank you. Does your client wish to make a statement?
I would like to apologize for our previous interaction. I know they weren't good, but I feel like it was a misunderstanding of who I am and my character. So I greatly apologize. My please ask the court not to send me to jail.
Previously went very light on sentencing with you. When you pled guilty to the OWI first offense, I only sentenced you to 90 days, 3 months. I did that in June. Would have been done by now. But for the fact that there's been multiple violations during the course of the time that you've been on probation, and some of the violations likely stemming from or resulting in new charges. I don't know if there were charges ever issued as it relates to the incident that allegedly occurred back on July 10th. But all of those things being concerning to the court expressing to you at that time of that last violation hearing, the concern that we had about your combativeness, because that's a sign of something that's lingering, an underlying issue. And so there was also expressions made to law enforcement, according to my report, from your own loved ones about your abuse of substances and how that's what's triggering this behavior. But your family members, your attorney, substance abuse assessors, judges, probation officers, all telling you that there's an issue doesn't fix the issue. It's you understanding that there's an issue and that you want to do something about it. You are a mother, you have children. I'm sure you have custody of your kids. Is that a yes?
Yes, ma'am.
And I'm sure you would like to maintain custody of your children, correct?
Yes, ma'am.
You want to be present in their lives and be a positive influence, I would hope.
Yes, it's your honor.
But you can't do that if you're walking around in drunken madness, can you?
Correct.
You can't do that in jail either.
Right.
Probation is a privilege, it's not your right. You understand that?
Yes, ma'am.
We placed you on a term of provision and we carefully selected and crafted what we thought would be the best course of action for you so that you could be rehabilitated, so that you can provide the care that you need for yourself and for your children. But I can't twist your arm and force you to do anything, okay? I'm also not gonna go back and forth with people in the courtroom. You see how many people I have in here? I don't even have the time to go back and forth with people. I try to resolve their issues and give the best that I can to provide for their needs to be met, so we can move on and get you out of this. We don't want you coming back in here just like you don't want to come back in here. I don't want to put you in jail just like you don't want to go to jail. You understand that? What I want for you is to be healthy. So I appreciate that you've taken some measures to be reactive to what's going on with you psychologically or emotionally or whatever the such, you'll let a doctor determine that and getting the care that you need to. So because of that, I won't sentence you to immediate jail time, but I'm gonna hold some jail time over your head. 14 days Ingham County Jail for the violation, which will be suspended upon successful completion of the remaining term of your probation. You were supposed to end probation in January because I had extended it. This is your violation number 3. I'm gonna have to extend this again, another 3 months on top of that. And so I'm extending your probation an additional 3 months. I'm gonna add a scram tether so that you can be monitored more closely. Are you employed?
No, ma'am.
You're not employed.
I'm a homemaker.
Okay. I'm gonna require that you complete 24 hours of community service within the next 2 months. This should be easy because it's the holiday seasons. There's all kinds of things that you can get involved to give back to your community and help recenter and focus you, okay? Okay, maybe if you spend more time helping your community, you spend less time consuming some alcohol. Okay, let's get that within 60 days. You'll get a list from probation, okay? You contact them, ask them for the list of where are the approved locations that I can do community service. You don't get to just make up any place or tell me you went to your church and served, okay? You should go to your church and serve if you have one, but that's not gonna count, okay? You need to go to somebody else's church and serve, if that needs to be the case. I'm gonna continue your probation. I'll suspend the 14 days upon successful completion. You'll get information from your probation officer as to the scram tether. You'll go down and see your probation officer today before you leave, okay?
Okay.
Do you have any questions, ma'am?
No, Your Honor.
Okay, I'm also ordering that you follow through with your appointment for your psych or your psychologist and that you follow all recommendations, okay? Any additional matters for the record?
Nothing further. Thank you, Your Honor.
You're all set. Thank you. Good luck to you. Let's see here. Do we have attorneys that are here on landlord-tenant matters? Did you meet with the other party already? What's your name, sir?
This is for CV Lansing.
Okay, Michael Ball present?
Yes.
Okay, you never met with Michael Ball? Okay, this is for an eviction for non-payment of rent. You all should step out and see if you can work out a resolution. Okay?
Thank you.
Thank you. Anybody here from the Klug Law Firm?
Mr. Mock is in the hallway.
He's filling in. Is he talking to Ryan Cable, maybe?
I'm not sure.
Hopefully. Okay, let's see. And then, or he could be talking to Corey Blocker, I guess, because he has 2 matters. Okay, and then I have, is it Chelsea O'Connor present?
Yes, I'm present.
Please start your video. On the record in the matter of TNT Financial Inc. versus Chelsea M. O'Connor, file number 14-02636 GC. Counsel, could I have your appearance?
Good afternoon, Your Honor. James Meineke appearing on behalf of the plaintiff TNT Financial.
Okay. And then Ms. O'Connor is present via Zoom without an attorney, correct, ma'am?
Yes, ma'am.
Okay, today was the date and the time set for an objection to setting aside a payment plan. Let's see, the defendant filed a written objection. She said that you are formally object to garnishments of your wages as requested by Midland Credit. You believe this action is unfair and unjustifiable for the following reasons. You said that there's an exemption eligibility. You also said there's a financial hardship. You said you're a student, and you said there's the settlement that you're willing to work towards agreed settlement amount, and you have been making payments on this judgment for 10 years and have paid over $11,000 towards this judgment. And so let's see, you previously had did you previously have a installment payment order, ma'am?
Yes, we did.
Were you making your payments?
I was working with April. I paid about every other month to every 3 months and paid in a bulk sum because I was using my student loans to pay the amount for the months.
Okay, I saw you back on March 5th, 2021. You had a motion to set aside garnishment, which was denied. However, the parties did enter an agreement. I ordered an installment payment to issue, and so I put you on an installment payment plan. You were supposed to pay $100 per month beginning April 15th. You were supposed to make a payment of $100 every month, not every other month. Correct?
Which I was paying it every month, but due to having COVID and my son getting sick, I did fall behind on the payments, which I did keep them updated on, and they did agree to switch that monthly payment.
Well, I don't have any record of such. The court order is what we follow. We don't follow anything else because they had a court order to get $100 payment, and doesn't sound like they immediately sought a garnishment. And I'm assuming was this a garnishment for the income tax? Is that correct, Mr. Meineke?
There was a previous wage garnishment at Norton and Associates. We subsequently did file a state of Michigan income tax refund garnishment and served it on the state, but that's not the issue here today. It has to do with her suspending that garnishment on Norton and Associates in exchange for making the $100 a month payments.
Okay, I don't even see the copy of the garnishment in the file. Let's see here. I see a W-2 that was formed. Let's see. Okay, this was for periodic garnishment. And so, ma'am, you did not make the payments as you were ordered to make the payments. It doesn't even sound like you made the payments as you agreed to off the record. Like you were not being consistent. And so if you have a payment or an order for installment payment arrangement, which is a payment plan, why would it not be unjust for you not to make those payments?
I'm not saying it's unjust for me to do a monthly payment with them. I can't afford $100 a month, and I also can't afford them to garnish my wages and pull $400 a month from me.
Okay, well, the court rules give very specific reasons as to when and how you can object to a garnishment. You indicated an exemption eligibility. What is the exemption?
To them garnishing my actual wages versus the installment, because they set aside the installment and filed to garnish my wages from my employment.
Okay, that's not a valid exemption. You got to tell me what makes these funds exempt from being garnished? Meaning, these are protected funds, and why are they protected? That's what
I put it in as a financial hardship because all the income I receive from my employment pays all of my bills for the month.
Okay,
I don't have anything extra left over.
That's not an exemption under the law. That's you in your head term that as an exemption. The law doesn't make that an exemption. Because I only make enough money to pay this amount of bills, doesn't mean that this money is exempt. That's not how this works. People in America often make far less than what their bills are because we tend to live outside of our means. It doesn't mean that the funds that we earn become exempt. That just means we're in over our heads and we need to figure it out. You don't get to exempt those funds. So unless you can provide me with a lawful reason why the money that you're earning would be exempt, you can't be granted an exemption under the law for a garnishment. Financial hardship is not listed in the court rule as one of the reasons whereby an exemption would be invalid. You being a student does not make you or put you in a position where you would qualify under the court rule for an exemption from a garnishment. These are not reasons why you can object to a garnishment, ma'am. Lastly, a settlement. If there was settlement and the parties are going to enter a new order, then you and the attorney can work that paperwork out and write it, and they can withdraw their motion for garnishment if they'd like to. But what you're telling me now is that you have not consistently followed the order as you were supposed to, but that you don't want them to be able to garnish your wages. You were granted an opportunity after the last time that we had this hearing to still be on a payment plan, and you've not complied with that, ma'am. I can't keep letting you screw up the
TNT and
payment
I
plan.
came up with an agreement together.
Well, was
So
I in the
I'm-
middle of a sentence? Was I in the middle of a sentence when you started talking?
Sorry.
Counsel, do you have anything you want to add?
Just simply that the agreement that we had was $100 a month, and she's currently now $800 in arrearage. The last payment was made in May of 2023.
Okay, motion to set aside garnishment order is denied. Any additional matters for the record?
Judge, this is our motion to set aside the installment payment order. Will you enter an order setting aside the installment payment order as well?
That is correct. I do have your order present here in the file. I'll sign and date it for today.
Thank you, Your Honor.
Thank you. You're all set for today. Thank you. Mr. Dowrick is present on which matter? Is LaShawna George present? Oh, she's in my waiting room, actually. LaShawna George. I don't see her. She logged in. I don't know if maybe we lost her. I'll give her a couple minutes to try and relog in. There was a step to adjourn for Keisha Gonzalez and Ali Neal.
Yeah, but we didn't sign. I didn't give them the date.
Oh, okay. Is anyone present for them? Is Raheem Alec Neal present or Keisha Gonzalez? Doesn't sound like they're good.
Your Honor, legal services represents Ms. Gonzalez.
Oh, okay. You just need a new date?
Yes.
December 6th. time do they need?
How much time do you need?
2 weeks.
December 27th at 2:30.
December 27th at 2:30 work?
Yes.
Okay, we'll do that. We'll get you a copy of your notice if you want to stick around. If not, you're all set.
Thank you. We have a couple other matters.
Oh, okay, well then we'll get you a copy of your notice. Okay. Let's see. Okay, you're here for Blue Law Firm, correct?
Yes,
Did you meet with either Ryan Cable or Corey Blocker?
I just met with Mr. Cabell
Okay,
and we have a consent judgment ready on that case. I
okay.
have not spoken with Mr. Blocker.
Is Corey Blocker present? Okay, you can have Mr. Cabell come in and we'll take care of that one. I don't see Mr. Blocker present, at least at this time. Mr. Dowick, I've not seen Miss LaShawna George rejoin the breakout room. Or the waiting, she's not in my waiting room. She's attempted to log in, but I don't know what happened. And she's not logged back in. And so this was her motion. I'm going to deny her motion. If she does for some reason appear later, I'll reset it and you'll get a notice in the mail. You're muted, sir.
Thank you, Your Honor. Thank you.
You're welcome. On the record in the matter of CB Lansing, I'm sorry, I don't think I want to do that one yet. This is Mr. Cabell.
Yeah. Okay.
Okay, on the record in the matter of Logan Capital LLC versus Ryan Scott Cabell, file number 23-02455 LT, counsel appearance.
Good afternoon, Your Honor. Attorney Sean Mock for the plaintiff, P78785.
Sir, what's your name?
Ryan Cabell. I'm
Mr.
good.
Cabell. I'm good. How are you?
I'm all right.
Okay, very good. Today's the date and the time that's set for an eviction for non-payment of rent, and the parties entered into an agreement.
Yes, we did, Your Honor. We had the opportunity to speak and we have agreed to entry of a consent judgment in this case. The consent judgment reflects that the plaintiff has a right to recover possession. The total redemption amount is $18,022.48. And we have agreed that a writ shall not enter before 12/29 of 2023. No money judgment is requested or entered at this time. And regarding further orders, the defendant has agreed not to hold any events at the property. May I approach?
You may.
And the tenant has also completed an advice of rights form.
Okay, and Mr. Cabell, that is correct?
Yes, ma'am.
Okay, so you read this document?
Yes, ma'am.
You understand your rights here?
Yes, ma'am.
And you want to give up these rights?
Yes, ma'am.
Okay, so you are to have judgment entered against you by consent, correct? Okay, and you're entering a judgment whereby it says the rent to retain is $17,859.60 plus court costs of $162.88 for a total amount due to retain of $18,022.48, that you'll either pay that in full or vacate the property at the address of, is it what is the address of the property?
3222 South Martin Luther King Jr. Boulevard, Suite 41.
Okay, because this has his personal address. Let's see here.
Yeah, it is a commercial property.
I'm gonna write that in on this here, 322. Number 41A.
Correct.
Okay, so you either pay that amount in full or vacate of the use and possession of the premises at 322 South MLK number 41A, no later than the 29th of December, correct?
Yes, ma'am.
Okay, and that you further agree that no events may be held at that premises, correct?
Yeah, I'm ready to get out of here.
Okay, no money judgment will enter at this time, and you understand, sir, that you have the right to be represented by an attorney?
Yeah, I couldn't get one.
Right.
Everybody I talked to, they said they don't represent commercial property.
Okay, so you weren't able to,
I wish I could have had one. Everybody I talked to, they said they just don't do commercial property. Last time when we had that Zoom meeting, I got switched over to one of those attorneys or whatnot. They took my information and they called me back.
one of the legal services? So
Yes, ma'am.
yeah, I'm sure legal services doesn't have the capacity to represent commercial properties. They're inundated with people who are losing their homes.
Mhm.
Okay, so.
Well, I
but
lost
you-
my home invested in this place.
But you were living at this property?
No, I live
Oh,
in Flint, but I spent over
Got it.
$50,000-$60,000.
Okay, I understand that. You had the right to hire an attorney, though. Did you hire an attorney for today's purpose?
Yeah.
Okay, and you had the right to request an adjournment so that you can get an attorney to represent you. You did have a pre-trial on October 10th. And then we set this matter over a month out, which would have been more than sufficient adjournment time for you to obtain or retain counsel. So are you seeking to waive your right to counsel today?
I'm ready to end it all.
Yep, I understand that, but I asked you a direct question.
Yes,
Okay.
we're waiving counsel.
Okay, very
We're gonna
good.
end it today.
And you had a right to proceed to trial. You had the right to have a trial by judge or by jury. Did you understand that?
Yes, ma'am.
And you want to waive your right to trial, sir?
Yes, ma'am.
Is anybody threatening you to waive these rights?
No,
Any force being made against you to get you to waive these rights?
no.
Okay, and you signed this document? You have 3 business days from today. If once you leave here, you realize, you know what, I did misunderstand the rights that I just told Judge Simmons I understood. You can return to the court. You'll go to the civil clerk's office and you'll file a motion to set aside the judgment. You'll have to explain how you misunderstood your rights, okay?
Yes, ma'am.
Do you have any questions today?
No, I do not.
Any additional matters for the record, counsel?
Nothing for the.
We'll get you a copy of the paperwork, sir.
Thank you.
You're welcome. I think Ball and King Jar are still outside. Is Corey Blocker present?
I believe he's incarcerated, Your Honor.
Really? What makes you feel that way? I too. You mean he was incarcerated after the time of him filing this motion?
I don't know the date he was originally incarcerated.
I have here that he filed this motion on November 19th. I don't even see where it was signed by a judge. Let's see the file. He's where? Jay. Okay, yep, I see where he did file a response to the complaint from jail. On the 19th. October. Retrial on that?
Pre-trial is actually set for tomorrow morning at 8:15.
What is the motion? What exactly is the motion? It just says motion, and they're not telling you what kind of motion it is.
Title of the motion is motion to reschedule this hearing and motion for a case manager to schedule discovery.
Okay, so this is set for pre-trial tomorrow.
Correct.
Well, let's see, in Ingham County Jail. Do we know how long it's gonna be? Is he for us? Okay, we put him on the jail list for tomorrow. We'll see if we can get him tomorrow.
Okay, thank you, Your Honor.
Thank you. We'll just address this and the pre-trial tomorrow, I suppose. Dismissal. So when you going to come back from ball? Bio Trice?
Yes, ma'am.
That's you, sir?
Yes, ma'am.
Okay. On the record. Up to table, sir, in the matter of Bio Trice versus Mike Johnson and the Kitchen Shop in file number 23-03022 GC. Council appearance.
Good afternoon, Your Honor. Brock Veenheis on behalf of the Kitchen Shop and Mike Johnson.
Okay, today was the date and the time that was set for a motion for a more definite statement. Council, you filed this complaint or this motion, I should say?
Yes, Your Honor. My clients are the Kitchen Shop and Mike Johnson. They're located here in Marshall, Michigan. They were served with an affidavit and claim that was filed by Mr. Trice on August 22nd of 2023. They were served with that about a month later or so, and a date was set for small claims court. The Kitchen Shop being an entity, a business entity, a corporation, asked that I get involved, and so I filed a demand to remove the case to district court so I could file an appearance, which I have done. And contemporaneously with that, Your Honor, I filed a motion for a more definite statement because the affidavit and claim that was filed by Mr. Trice, as with all affidavits and claim, is a bit vague as to what the allegations were and the claim being made under the law, Your Honor. Today, earlier this morning, just before lunch, I did receive today's mail, and Mr. Trice had sent to us, and I'm not sure if it's in the court's possession, sort of a narrative of what his claim is. It's about a page, single-spaced, with attachments, Your Honor. It's still not necessarily in compliance with MCR 2.111A, which requires single allegations, concise allegations. It's more of a narrative, but it does outline the claim a little bit better, which I can only assume because it doesn't state as a breach of contract claim, Your Honor.
I don't have a copy of that. Did you file a narrative, sir?
Yes, ma'am,
Do you
I
have a
did.
copy that you can get, that you gave with the court already?
Yes, I do, Your Honor.
I know we just received this today. Was it with this?
No, it was yesterday morning.
Oh, okay, wait a minute. I might have it here. This,
Yes, ma'am.
okay, let's see here. And so you want a more definite statement. I'm just glossing over this outline. I don't see how this is not clear.
Your Honor, so we filed our motion on 11/8, so November 8th.
Oh.
We just received the narrative this morning, and I haven't even had a chance to get it to my client to review with them just yet.
Oh, okay.
So that was,
That's
I believe Mr. Trice did that in response to the motion.
Okay, so I would construe, just based on the allegations, and what little information I know, that Mr. Trice is alleging a breach of contract due to some cabinets that you ordered.
That's correct, Your Honor.
Okay, I am not, and I recognize that this paper filed, I think the court got it on November 27th, that highlights or describes what his concerns were, as well as the attachment does not necessarily comport with the court rule, but he is a layman. He's not an attorney. Did you go to law school, sir?
No, ma'am.
Okay.
I don't want to
Have
be.
you ever worked in a law office?
No, ma'am.
Oh, okay. I would probably have better luck winning the Mega Millions and getting him to file a complaint that comports with the court rules. He did file this as a small claims, which would have been fine. You moved it to the general civil division, and so I'm not going to require him to figure out how to be a general civil litigator real quickly. I think that this summary that he's written here is pretty clear as to what his concerns are. And I'll even allow there to be some directed discovery. If you need to ask interrogatories or questions to get further information, that's fine. If after you review this with your client and you believe that this still doesn't reasonably place you on notice as to what the cause of action is, I'll allow you to renew your motion, okay?
Yes, Your Honor, and like I said, this wasn't in response to what we received today. It was just the affidavit in claim, and so there is another issue, and it may be addressed in another motion, Your Honor. Mike Johnson, who is appearing via Zoom today, as the court may see, is an employee of the kitchen shop, but he is being sued individually. I guess I can raise those defenses in an answer and file a motion to remove him as a defendant if the court seems fit, deems that's fit.
Yeah, correct. You can file a motion. It sounds like he was an agent of the company, and agents can be sued directly as well. I would just need to have more information to know why he was named or what role he played. But it sounds like, based on what is written here, Mr. Trice had direct dealings with Mr. Johnson.
Yep.
Mr. Johnson, you wanted to say something?
Trice.
I'm sorry, Mr. Trice, I'm sorry, you wanted to say something?
Your Honor, I went and obtained an attorney. If you look through the notes, you'll see that I even went out and paid $1,000 just to resolve this, so I didn't have to come to court. And Mr. Johnson knew that all of that time we were trying to get with him, as you can see in the attorney that I hired, neglected even to contact him or to get with me. All I wanted to do was just settle it. But the damaging part of this whole thing for me is that they bought me these drawings, and at the end of the day, none of these drawings fit where the cabinets were supposed to have went. And if you read the notes where I stated that they wanted to charge me for new cabinets based on the fact that their contractor or their planner came out and drew all these plans up, and knowing that those plans were wrong, and even after the gentleman Randy had left, I attempted to contact the kitchen shop. At that time, Mr. Johnson came out to my house, insulted me by saying that, yeah, we cut all your cabinets and stuff wrong. It's only worth $2,000 to them. So he was speaking on behalf of the company as the representative that was going to pay the $2,000. So where he comes up saying that he was just an employee, well, if that's the case, then he brought his assistant, which is his bill director, out to represent him, saying that Mr. Randy in his measurements were totally wrong. And if you look at the measurements that was presented, you will see that she came out and literally wrote on the paperwork to show that those measurements were totally wrong. So for all of this to come back and say that he was just an employee, he didn't act like an employee that day when he insulted me and said that he thought I was wrong for not accepting his $2,000. And at the end of the day, all of the things here that was done at the end of it, I ended up having to correct all of the problem because of the fact, if you look at the one cabinet here that he was supposed to have put at the corners of each windows, he ended up putting it underneath the windows. And that is not a part of the drawing. And if you go back and look at the drawing, you'll see that those drawings does not line up with the plan that he had that was supposed to have been the drawings for it itself.
So
now I sent also.
So let me stop you because today's not the day for us to go through into your proofs. You did provide a lot of proofs attached here. And if he files such a motion, trying to remove Mr. Johnson from the case, all of these things that you're sharing would be useful for you to respond and put in your writing, because if he files a motion, it's your responsibility to respond to that motion timely and in writing, okay? So you make sure you don't miss any of those things. I'm also going to make sure someone confirms your address before you leave. I don't know whose mail's coming back undeliverable. It's not yours, but I want to make sure we have your information. And then the defendants are represented by an attorney, so they'll get notice through their attorney of our next court dates. I do see here a letter that was signed here by attorney Melvin McWilliams. Did you only retain him for the purposes of trying to mitigate the damages, meaning trying to work out the issue?
Just trying to resolve the whole case as a whole.
Oh, okay. You did not hire him to represent you for this.
The only reason I didn't is because at the last minute, this was all
small claims
come to me after the fact, which he was not able to come because of me not being able to give him the necessary things that he required. Those
you mean Mr. McWilliams?
McWilliams, that's correct.
Oh, okay, so if you do retain him, he will file his appearance, and then he will be in contact with the defendant's attorney versus you after that point, okay?
Can I ask one last question?
You may.
See, now in that particular case, there was a requirement, like I heard the gentleman say earlier, couldn't get an attorney to come and do this. Every attorney that I talked to, as you can see in the attorney that I hired, he wanted $5,000 to bring it to this situation, when in fact, I mean, self-explanatory, this is wrong. And I do the same thing for a living for 40 years. And I've never
do what, contract work you mean?
Yes, I've
okay.
been doing it for 40 years. As a matter of fact, I sent you all of these are called reviews from Home Advisors. I have over 80 of them, 5 stars. And so to me, service is what this speaks of. And I didn't get none of that. And I decided just to let someone else come in because I retired, just to see what it felt like to have someone else to do work for me. And this is what I got.
Oh, so you have experience in this, so.
Oh, yeah.
Okay, got it. Okay, well, I have not looked at any of that information, and that's partially because now's not the time for proofs. So any evidence that you want to enter has to come in at the right time, and you need to make sure you serve them a copy with that. And I'm sure you have. I don't know if they received it.
They received it already, like you said, he received all of that.
Yeah, we just received it. I think our civil clerk brought it up in the middle of my last proceeding, so I do have it here in the file. I have not looked at it, and I won't look at it until the time comes if I'm going to hear a hearing relative to that, or if you would proceed with your trial, okay? Then I will, when it's admitted as an exhibit is when I will review it. I don't review those packets prior to, because it would be improper, okay? Okay, so you are continuing to compile your paperwork. What's gonna happen next, unless the defendant's attorney files another motion, is there is going to be a pretrial date set. You'll get notice of that from our clerk's office if you have not already. And once you get that pretrial, you'll appear, both you or your attorney, if you hire one, and the defendant's attorney. My requirement is that you meet privately to try to either negotiate settlement, or you can come up with, we call a pretrial joint pretrial statement. And so that means both parties are just going through and talking about timelines, because we're going to use that to give you your next court dates, which would be the deadlines to do discovery. Discovery is when you want information that you believe will either help support your cause of action or refute whatever they're saying, meaning they may have a copy of the drawings and you don't have them, so you're demanding it from them. That kind of stuff is discovery, and you can Google the court rules if you want more information about discovery practice. But what will happen is we'll give you a time period to do discovery and the cutoff for that, and then after that there'll be a time frame for you to file motions. Typically a plaintiff may file a motion for summary judgment, or the defense may file a motion to dismiss for, no cause of action, something to that effect. There'll be a timeline for those motions to be filed, and then you also get your timeline after that pretrial for your trial. I don't believe there was a jury demand. Is that correct?
Not to my knowledge, Your Honor.
Okay,
We
so
did
then
not
there'll
make a
be
jury demand, Your Honor.
okay, so it'll be set for a non-jury trial.
Can I request a jury trial?
You would go downstairs to the clerk's office and you can make a jury demand. You have to pay the fee for that, okay?
I'll pay for that.
Okay, so.
I'm sorry.
Yes.
One last question.
Yes.
Now, we attempted mediation and they never showed up. So when you say we go back and do the mediation part and all of that, we went there too. And that was never done even now, which is what I was hoping for, because I really didn't want to come before you because of the fact that I'm a man of God and I don't believe in suing people, but they forced my hand to come here. And that's unfortunate.
I understand. A mother that believes the same thing. But the courts are here for a reason.
Yes, ma'am.
And so we help resolve issues. I do see that there was paperwork in the file relative to mediation.
Right.
I don't know that they received that paperwork because I do have a return to sender form here.
Can I share something with you on that? I was talking to the mediation people every day up until they attempted to call Mr. Johnson on 3 different occasions. And because he didn't respond to any of them, that's why it was moved over to court.
Okay, well, this is something that we can obviously order mediation for if the court believes appropriate,
I'd appreciate it if you could.
we will discuss that better at your pretrial though. So all of that will be on my joint pretrial statement, whether or not there needs to be case evaluation or mediation set. That can be ordered if I believe that it's appropriate way to resolve this. Okay, sir?
Appreciate that, Your Honor.
No problem. Do you have any other questions for today?
The pleasure being in your presence, Your Honor.
Thank you. Any additional matters for the record, counsel?
Your Honor, my client is not opposed to mediation, and I believe that they did actually attempt to contact the district court when this was still in small claims, and the time frame to do so had passed, and they had set a date. And so I'm not sure if there were phone calls made or not, but I think that the idea of mediation is still on the table, most certainly, and I just want to make that clear to the court.
Yes, I guess the best way, Your Honor, to prove whether or not that's true or not is talk to the gentleman that was calling them every time to see why they didn't return the calls on the mediation. So that is the best way of finding out whether or not either I'm telling the truth or they're telling the truth.
Okay, I'll leave that to counsel if he wants to talk to his attorney. And I'm not necessarily interested in as to who's telling the truth and who's not at this point. I'm interested in moving it forward. And so at this point, if there's going to be a court order for mediation, then that will be the expectation. Sounds like he's not opposed to mediation. Based on the limited information I have, think mediation may be beneficial in this particular matter. And so we'll seek to get an order. And for that, once we have our joint pretrial statement, you're going to go downstairs 1 floor to the 5th floor. You're going to do 2 things, make sure they have your accurate mailing address. And then you're also you want to request a jury demand. You want to enter a jury demand, you'll let them know that when you go downstairs. Okay, sir?
Thank you.
Okay, any additional matters for the record?
No, Your Honor.
Thank you. You're all set for today. Thank you.
Have a good day now.
You too. Okay, there's this one. Is that it? Very good. On the record, the matter. Sorry, what's your name?
Kaishir Scott.
Okay, well, ma'am, you're at 3 o'clock. I have some people that are before you. So you can have a seat there. We'll call your case in just a moment. On the record in the matter of Woodside Meadows versus Robert Kyle, file number 23-02494 LT.
Good afternoon, Your Honor. Mike Zappel, P6807 on behalf of the plaintiff.
Okay, and you're Mr. Robert Kyle?
Yes.
Mr. Kyle, I think I know your son. You have a junior?
You know, all my problems.
Okay, that's what I thought. Okay, how are you today, sir?
I'm good.
Okay, today is the date and the time that's set for a hearing for non-payment of rent. You all came to a resolution?
Well, Your Honor, there's a rent to retain position at $6,796.64. Cost of $155 for a total of $69.51.64. Mr. Kyle has indicated to us that he has made application at a couple agencies for funding, help him pay for this.
Okay, what agencies?
It was the ones that were on this form. I received a contact back from one of them saying that they couldn't help me because of, I guess, where I make it my job.
And have you heard from some, you have some still pending?
Just one.
Just one pending, and where is that?
That's at the,
You don't recall where your applications are pending, sir?
it might have been this Office of Financial Empowerment.
Office of Financial Empowerment, the city of Lansing, I believe that they're no longer in existence. Did you talk to Mr. McDonald with the housing ombudsman for the city, maybe?
It was a young lady that contacted me, and then when I came to court that, or actually get it on the screen, the young lady that you had me speak to there, she sent me an email saying that they were gonna look into it, because I told her
that my finances was changing, and so she was gonna try to see if they could help me. But,
Okay, so did you ever fill anything out for assistance?
I filled out with her over the phone.
Over the phone? Okay, the reason why I'm asking you this is because the rules have changed since the last time you were in our court. And so now if you do have an application pending for rental assistance, I have to stay the case. So I'm trying to establish if you actually have an application pending.
Mhm.
And you're certain that you do.
That was with her.
You need to know who it is, because what you're gonna have to complete is this form here that tells me who it's pending with, so that I can stay the case. I can't stay the case unless I know who it's pending with. I'm happy to reset this for our next court date, so you can find that out and get this paperwork completed so I can stay the case, okay? So that's what I'll do. I'll give you a next court date. You need to go find out who your application is pending with. And then I can get this paperwork completed to stay your case if necessary, okay?
At 3:30.
December 6th at 3:30 is your next court date, okay? Any additional matters on this file? Okay, you're all set unless you have questions for me today, Mr. Kyle.
And at what time?
At 3:30, we're gonna give you a notice to appear. Do you have any other questions? Okay, you can have a seat. We'll get you your paperwork. Thank you. You didn't meet with Devin Hayes, have you? Because he or she has been on our Zoom for some time.
Devin Hayes, yes.
You met with Devin Hayes?
I have not.
Okay. Devin Hayes, are you there?
Yes.
Okay, we're gonna get the attorney on Zoom in just a moment, but you did meet with Scott? Is that correct? Did you meet with Ms. Scott?
I have met with. No.
Who did you meet with?
We met with Mr. Fonto.
Okay, Montel.
Ms. Her has counsel. They're discussing their case at this point. And
Perkins has counsel as well.
And Mr. Perkins has counsel, and we think that's going to be.
We'll do Fronto on the record in the matter of Woodside Meadows versus Josue Fronto, file number 23-02488 LT, counsel appearance.
Thank you, Adam Michael Zappin, T68107 on behalf of.
Mr. Fronto, you don't have an attorney, correct?
No.
Did he get his notice already? Mr. Kyle, you're all set unless you have a question. Did you need me? All right, sounds good. So today was the date and the time that was set for a hearing for non-payment of rent. Did the parties come to a resolution?
We did not.
Okay, so you want to proceed with the hearing?
Yes, sir.
Okay, this is for non-payment of rent. Okay, and you believe that you have a lawful reason to withhold your rent, sir?
Yes.
Okay, and just generally, or briefly, I should say, what do you believe that reason is? Was there condition at the property?
Yes, the city of Vincent.
Okay, so
you know that the windows.
you believe the property be red tagged or there was a condition issue?
Yes.
Okay, and you previously met with legal services?
Actually, I thought last time I was here, nobody never called.
You said
I don't get no phone call.
you never
no
called them
email,
back, and
no.
did you try again?
No, I don't.
Okay,
I
well,
believe-
before you leave here today, it might be beneficial for you to speak to this lady here and see what number you can call so that you can get a return call, okay?
No problem.
Okay, and then I'm have to set this for a hearing. I can't do a hearing at 3 o'clock because there's so many other people that this same attorney needs to meet with today. So we'll set this on a date and time where we can start it before 3 o'clock, okay?
January 3rd at 1:30.
January 3rd at 1:30. Okay. Do you have any questions today?
Yes, my lease gonna be expiring in December, so I don't know which days, so.
You don't know what?
My lease gonna be expiring in December.
Your lease is expiring in December. Are you planning to move?
Yes, I'm looking for a place to move.
Okay. Okay, well, your lease expiring is a separate issue from this eviction, of course. This is for non-payment of rent. Okay. However, if you do relocate, you should notify the the plaintiff immediately and make sure you turn over your key, do a walkthrough to make sure they're not alleging any damages to the property, okay? And then they can move forward. I don't see where there was a money damage complaint on this, correct?
That's
No.
correct.
Yeah, so if you vacate the property, they have the right to go ahead and dismiss the case against you, okay?
One more question. Is there any place I can call for a complaint about some staff who's not fixing and stuff like that? And then
You're alleging a code violation issue. You need to call city code enforcement, okay?
I have that information.
You would have to Google that.
Oh, Google that?
Okay, yep, you have a phone?
Oh, yeah, I do.
Okay, yep, you can Google the city of Lansing code enforcement, okay?
Okay.
Okay, you're all set unless you have another question, sir.
Thank you so much.
Thank you. Okay, you haven't spoken to anyone else yet, though, correct?
I talked to counsel.
Okay, counsel is ready on her matters? Or you still need to discuss?
I believe we have a, yeah,
This is for her?
sure. Her and for her.
You're ready or you need to talk?
I agree with that.
Yeah.
Okay, on the record in the matter of Woodside Metals versus Maria Her, file number 23-02492. Council, may I have your appearances?
Good afternoon, Your Honor. Michael Zappin, P68107 on behalf of.
Good afternoon, Your Honor. Jessica Massa, Legal Services, on behalf of Maria Her, who is presenting to my right.
Thank you. Today is the date and the time that's set for a hearing for non-payment of rent. And my understanding the parties have come to a resolution.
Well, Your Honor, it's, Ms. Her is has applied for rental assistance and her application is processing. So it's my understanding that council and I have agreed to adjournment in her case.
Whatever pleases the court. I know that that's going to require an adjournment.
Yeah, there's a requirement now that if they've applied, we'll stay the case. And so we can stay the case pursuant to Michigan Court Rule 4.201 L3. Where is the application pending?
She has an application pending with DHHS and with Housing Services in Michigan.
Okay, so we'll stay the case until the time that a decision on the assistance is rendered. And then counsel, you'll notify the court once that decision comes, okay?
Yes, Your Honor.
Okay. Any additional matters on this file today?
Nothing, Your Honor.
No, Your Honor.
Okay, you're all set. Thank you, ma'am. And your other matter, Perkins, you're ready on too?
Yes, Your Honor.
Okay, on the record in the matter of Woodside Metals versus Jeffrey Perkins and file number 23-02495, counsel appearance.
Thank you, Your Honor. Michael Zappin, P68107 on behalf of.
Legal Services on behalf of Mr. Perkins, who's present seated to my right.
Okay, Mr. Perkins, today was the date set for a hearing on a non-payment of rent eviction, and how are the parties looking to proceed at this time?
Apparently we're gonna reach a consent agreement. The rent to retain possession stands at $6,475.67. Cost of $155, total of $6,630.67. There is no money judgment that we're seeking, so just a consent judgment. If he doesn't pay by January 1st of 2024, we will vacate the property.
Okay, and that's a complete and accurate understanding of the consent.
Yes, Your Honor.
Okay, counsel, you can either approach or can you get that from him, please? Okay, so I have a consent judgment. You want to enter judgment against yourself? Is that correct?
Yes, sir.
Okay, and so you understand that you had following rights. We have an advice of rights for him, for landlord-tenant over there. He needs to complete an advice of rights for landlord-tenant. If not, we can get you one.
It's just criminal in here.
Okay, sounds, she has one right here. This is what's on the. Oh, yeah, no, that's not the one we use. Yep, you can go get it from your report. Off the record. So what? Yeah, this is the new form that, but it doesn't give a where for them to sign them. Where's the signature line? $6,475.67 plus court costs of $155 for a total of $6,630.67. And that you'll either pay that in full or you'll vacate the address no later than the 1st of January 2024, correct?
Yes, sir.
Okay, and so you understand that you had the right to be represented by an attorney, and you are represented by an attorney at today's hearing, correct? You also have the right to have a trial, and you can have a trial by judge or by jury. Would you want to waive your right to trial? You do not want to waive that? You want to have a trial in this matter?
Yes, I'm sorry.
Oh, okay. Is anybody threatening you to get you to waive the trial in this matter?
No.
Does anybody make any promises to you off the record to get you to waive your right to trial? Okay. Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you have waived in order to enter into this consent judgment, you can return to court. You can request to have this judgment set aside. Okay, sir?
Yes, ma'am.
Do you have any questions for the court?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing, Your Honor.
No, Your Honor.
Thank you. You're all set.
Thank you.
You're welcome. And let's see, we need you to meet with Mr. Hayes first, and then is Shanae Jones present? Anybody present for Shanae Jones? Okay, sounds like Shanae Jones has failed to appear. And so you can submit default for Shanae Jones. Okay, who else is here? I know that we have Miss Scott here. What about Diane Warden? Is Diane Warden present? Anybody else waiting for court? Okay, you're ready. I have yours. Okay, sounds good. If you want to log on to Zoom, do you have ability to do that? I can put you in a private meeting room with Mr. Hayes.
Okay, what is Zoom?
876 493 1931
901.
1931.
It's on that blue form there too, sir.
Oh, great, thank you. I'll be right back here.
On the record in the matter, CB Lansing 300 LLP versus Michael Ball, file number 23-02332 LT, council appearance.
Good afternoon. Thank you very kindly, Your Honor. Gary Kanjar representing the plaintiff, CB Lansing 300. Parties have reached a consent decree, Your Honor.
Okay, and so you want judgment to enter by consent, correct?
Yes, Your Honor. On the terms of the judgment signed by both parties, I believe Mr. Ball has signed the waiver.
Okay, this is for non-payment of rent, but it says rent to retain possession is $0.
Right, Your Honor. We've negotiated this to a zero rent situation for Mr. Ball. Seems like he's had enough troubles. He agrees to move out December 1st. We only reserve any right to claim damages to the premises should there be any damages. And finally, Mr. Ball has agreed to contact Advent House because they may be able to provide rent assistance for him, which may be able to be paid to my client. It's not a guarantee. If Advent House were to be out of funds or be unable to pay rent, that's it. There is no other obligation on his part but to try his best to get the rent assistance. There's the judgment of possession. Exit date would be December 1st. No money judgment, Your Honor. Thank you.
Okay, a couple of things. My understanding is that Advent House is currently out of prevention funding as of November 15th. So
I wasn't aware of that.
I assumed as much, but I was aware. Avid House is out of funding. However, if your balance is less than 3,000, they suggest you contact St. Vincent de Paul and seek assistance there. If you're 60 years or older, you would contact the Tri-County Office on Aging. If you're on Section 8 or subsidized housing, you can contact HRCS, which is right on the 4th floor of this building. If you're in the military, or if you served in the military, you can contact Michigan Veterans Trust Fund. And then anyone in a home that was affected by the AIDS virus in any way would contact Lansing Area AIDS Network. So, and then of course, DHHS. And so have you already applied to DHHS?
No, I haven't.
Okay, so that would likely be,
Okay.
who you contact, because Capital Area Housing Partnership also is out of funding. So
So who did you say had funding right now?
funding DHHS would be one of the
DHHS?
options.
Okay.
Yes. If your balance is less than 3,000, you can contact St. Vincent de Paul.
Okay.
And then you don't appear to be over the age of 60, is that correct?
Yes, you're
Okay,
right.
so you would not be able to contact Tri-County. However, if you are on Section 8 or subsidized housing, you could go down to the 4th floor and contact HRCS.
Okay.
If you served in the military, you can contact the Veterans Trust Fund. Or if your home was affected by AIDS in any way, you can contact the Lansing Area AIDS Network. And I believe those options may be listed on there. I don't know if they're on the front or the back. Nonetheless, I'm not 100% sure, to be honest with you, how this works, where you want judgment to enter for $0 and he has an agreement to vacate by that date, but that he can maybe pay an amount. What is the amount that he would be ordered to pay? Because it says $0.
It's just an attempt, Your Honor, because it would be a third party pay. If the third party is unable to pay, there is no judgment or money judgment against Mr. Ball.
Right, but it doesn't even say what they would pay. It says they contract to pay what? Because is it for future rent?
No, Your Honor, for past rent. It's not a
Well, then
judgment
they-
against Mr. Ball.
Right, well, judgment, this here is judged for judgment against him. This is for a
For
consent
possession
judgment.
only.
Yeah, and you still need to put the amounts, and it's just for possession. It's not for money judgment. So possession judgment, I still need the amounts past due plus the court costs and the total that he would have to pay if he was going to stay. I still need that.
Okay, I have those numbers, Judge.
Okay, I'm gonna get you a new form because this needs to be actually, let's not do all of that. Let's just I'll wipe these zeros out and you can enter those numbers there. Make sure he agrees with those numbers. As to money judgment, we'll leave the zeros there. That means no money judgment will enter against him. And according to what I understand, if he either pays the amount that you're gonna put in here or vacate by December 1st, then you guys are happy. That's what it sounds like, correct?
Yes.
Correct. And then if there's no money judgment entered and it sounds like you're really trying to work with him, you also have the option of a conditional dismissal, whereby you can dismiss the case today, still enter the same agreement that he'll pay a certain amount or vacate by the 1st, and that he'll contact for and try to make arrangements for assistance if he can get rental assistance. That way judgment won't enter. This still has a judgment that's going to enter for possession whenever we do a consent judgment. So if your goal is to not have judgment enter in against him, you may want to consider a conditional dismissal.
Well, we would still need judgment in case the defendant did not move, for example, we would have a right.
With conditional dismissal, you still have that right because the conditional dismissal is dismissed upon the condition that he either pays the amount that you tell him to or vacate by the date that you tell him to. If he doesn't, you can immediately seek judgment to enter against him in a writ.
Right. Plaintiff is not willing to do the conditional, Your Honor, only because, as I said, we're giving up a lot of rent here. We're seeking to just get possession and reserve the right for damages.
Okay, so then with that case, just enter those numbers on here
Thank you,
on this form, and then I can get that on the record.
Yes, I'm willing to vacate by the date. I will be out of there by the 1st.
Thank you.
Yes. So that just means I owe no money, just vacate by the 1st, right? And I will try to get help though to pay it back as much as I can.
Thank you.
Yes.
No problem.
Just initial by those numbers, sir.
Just initial by the number. But that's like when I initial, it's just like as long as I'm out by the first and try to get it paid, there's no money owed.
Correct.
Okay,
Unless you intend to stay.
no, I'm gonna be out of there by the first, for sure.
Thank you, Your Honor.
Thank you.
We've agreed that there's $6,195 rent to retain possession. Other money due $245. Costs $196.16 for a total of $6,636.16, Your Honor.
And so you agree to those amounts as the rent to retain possession?
Yeah, as long as I'm out by the first, though, I don't owe that amount, right?
Okay.
Correct?
Yeah, so rent to retain means just that. This is what you gotta pay if you wanna stay in the property.
Okay, yes.
So you agree that the amount due is $6,195 plus other money due $245 and court costs of $196.16 for a grand total $6,636.16. And that you will either pay that in full or vacate the property by December 1st, 2023,
Yes,
correct?
ma'am.
Okay, and the plaintiff is reserving the right to seek damage if there's damage done to the property. So I recognize, sir, that you have stated that you're gonna move out the property before December 1st. If you do that, you will schedule a walkthrough with the plaintiff, correct?
Yes.
And turn over the key before December 1st, correct?
Yes, ma'am.
Okay, no money judgment is to be entered at this time. They're not seeking money judgment at this time. And that you are going to make efforts to seek rental assistance, if that's something you want to do to stay in the property, or you're just going to vacate by December 1st?
Yes, I'm gonna vacate, but I would still look at trying to get the back rent paid to them.
Okay, and then you also have an advice of right here that you reviewed, correct?
Yes,
Do you understand these rights?
yes, ma'am.
You had the right to be represented by an attorney at today's court date. Did you understand that?
Yes.
And you had the right to be represented during this eviction process. You did not appear with an attorney today. Are you waiving your right to counsel?
Yes, I don't know what that means.
Well,
Wait, my right to-
counsel is an attorney.
Oh, yes, yes.
Okay.
Okay,
Okay, very good.
I'm sorry.
No problem. And so you had the right to request an adjournment to request legal assistance. However, this matter was originally scheduled back in August, and so you had more than sufficient time because the court built in an adjournment time just to get you to the hearing date. Okay, and then you have the right to have a trial. You can have a trial by judge, or you can have a jury trial. Did you understand that?
Yes. Yes,
Did
I
you
do.
want to waive your right to trial?
Yes, I want to waive my right to trial.
Anybody threatening you to get you to do that?
No, ma'am.
Any promises being made to you if you waive your right to trial?
No.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood your rights, you can request to have this judgment set aside. You will return to the civil department of the court. You will file what's called a motion to set aside judgment, okay?
Yeah.
But you only get 3 business days to do that, okay?
Yes,
Do
I
you have any
understand.
questions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you. Very kind.
Thank
Very
you.
patient. Thank you.
No problem. You're all set. We'll get you a copy of your paperwork.
All right,
Okay?
thank you so much.
Have a good rest of your day.
Same to you. Are you all set with Mr. Hayes?
I am, Your Honor.
Okay, on the record. In the matter of Woodside Meadows versus Devon Hayes, file number 23-02491, council appearance.
Good afternoon, Your Honor. Michael Zappin, P68 107 on behalf of the plaintiff.
Mr. Hayes is present via Zoom without counsel. Today was the date set for hearing for non-payment of rent. Do the parties come to resolution at all?
We have, Your Honor. I talked to Mr. Hayes. He just got back to work. He does have a balance of $5,325.85. Court cost of $155, a total amount of $5,480.85. He's agreed to pay that amount or vacate by January 1st of 24, and we're not seeking a money judgment at this time.
Okay, so it's judgment by consent?
Yes, sir.
That's correct, sir. You want judgment to enter by consent?
Yes.
Okay, you have a copy of the paperwork already?
Do, Your Honor.
Okay, so sir, you have the right to be represented by an attorney at today's court date. You understood that, right?
Yes.
Okay, you're giving up your right to an attorney today?
Yes.
You have the right to have a trial, and you can have a trial by judge or by jury. Did you want to waive your right to trial to have judgment enter against you by your consent?
Yes.
Okay, so you want judgment to enter whereby you agree that the amount of possession owed or rent to retain possession is owed in the amount of $5,325.85 plus court costs owed of $155 for a total amount due to retain the property of $5,480.85, that you'll pay that in full, or you'll vacate the premise at 4449 Seaway Drive, City of Lansing by January 1st, 2024. Is that accurate?
Yes.
Okay, you did check that there was no money judgment at this time, but then I see that there's cost at the bottom. This is $155. Do we want to wipe that out?
Please.
Okay, sounds good. Okay, and so you have 3 business days, sir. If you leave here and you realize you misunderstood the rights that you gave up in order to enter into judgment by consent, you can then return to the court within those 3 business days, and you can request to have this judgment set aside, okay?
Yes, I understand.
Okay, are you giving us permission to sign this judgment on your behalf?
Yes.
Do you have any questions?
No, ma'am.
Okay, any additional matters on this file, counsel?
Nothing here.
You're all set, Mr. Hayes. Thank you for your patience.
Yep. Have a good day.
Thank you. I think that the last you have present would be Ms. Scott.
Yeah, definitely not to speak of this guy. Just take 1 minute.
Diane Warden present? I didn't see Diane Warden, so it looks like that's another default. Okay. Yes, sir.
Miss Warden, I do know that a woman who said she was Miss Warden's daughter appeared and indicated Miss Warden had asked her to appear because Miss Warden could not make it. However, not an attorney. Miss Warden does not currently have an attorney.
Oh, did her daughter leave?
I think he stepped out a moment ago. I thought she was going to speak with you, but she had.
Was that the young lady in the back?
Yep.
Oh, let's see if we see her still. We're already on Ms. Scott's matter.
We are, Your Honor.
Okay, on the record, in the matter of Woodside Meadows versus Kashara Scott, file number 23-02-497, appearance please, counsel.
Good afternoon, Your Honor. Michael Zappin, P68107 on behalf of the plaintiff.
Okay, and Ms. Scott is without counsel. This is an eviction hearing for non-payment of rent. Did you come to resolution?
We have, Your Honor. So Ms. Scott is just, again, getting back to work, so she's agreed to enter a consent agreement. She had the balance of $8,367.30, cost of $155, a total of $8,522.30. The Department of Complex has given her till February 1st of 2024 to pay that or vacate. No money judgment being requested at this time.
Okay, and that's how you want to proceed, ma'am?
Yes, Your Honor.
Okay, and you reviewed that paperwork already?
Courtroom.
You may. Thank you.
Thank you.
Okay. You don't have any pending applications for assistance, correct, ma'am?
Not at the moment, Your Honor. I was advised to reapply on the anniversary for the Housing Commission. I just had to wait until December next month to go ahead and
To apply for assistance. Okay, sounds good. Okay, so you want judgment to enter by consent. You indicate here by signing that you recognize that the amount of rent to retain possession is due and owing at $8,367.30, correct?
Yes, Your Honor.
Plus court costs of $155 for a total amount due to retain possession of $8,522.30. That's accurate?
Yes, Your Honor.
Okay, and that you agree to pay that in full or you're going to vacate the property completely by February 1st, 2024, correct?
Yes, Your Honor.
You understand that you have the right to be represented by an attorney?
Yes, Your Honor.
Are you waiving your right to be represented by an attorney?
Yes, I am.
Okay, and you also have the right to proceed to a trial. You can have a trial by judge or by jury. You understand that?
Yes, Your Honor.
Are you waiving your right to be represented? I'm sorry, to proceed to a trial, that is.
I am.
Okay, anybody threatening you to get you to waive those rights?
No, Your Honor.
Okay. Any promises being made to you if you waive those rights?
No, Your Honor.
Okay, we'll get you an advice of rights to complete in just a moment. And that's your signature at the bottom?
Yes, Your Honor.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights that I just asked you about, you can return to the court. You'll go to the clerk's office and you request to file a motion to set aside the judgment. You'll indicate to the court at your hearing how it was that you misunderstood your rights, okay?
Yes.
Do you have any questions?
No, Your Honor, I do not.
Okay, any additional matters, counsel?
Yeah, Your Honor. I don't know if I had a waive. We talked about the 56-day rule for eviction, and she's going to waive that. I don't know if I know that in the notes.
I do see, no money judgment. Okay, yep, I do see that she was advised that she may file a motion for new trial or motion to set aside the fall or appeal a bond which must comply with the court rules by November 28th. Is that what you're talking about?
No, just a 56-day rule.
Oh.
Seeking eviction. I was going to note that in the comments, and I don't think I wrote it.
I don't have any comments here.
Can I?
You may. And you want to read that, those are just the rights I just went over, and if you are agreeing to waive those rights, you'll sign that paperwork and get it back to the court officer, please. Yes. Thank you. Okay, you can pass that to him, so can you get that for her? Thank you. Okay, do you have any questions, ma'am?
I do not, Your Honor.
Okay, you're all set. Thank you. And then you need default for,
Yeah, well, we have it for Diane Worden, and I understand that she had a representative here. I didn't know if you wanted to enter default, or if you want.
yeah, I didn't speak to anyone and it was not an attorney, so. You can submit default for Warden and I think you had another one. I don't know if I signed it already though.
Yep.
I did, okay. Sounds good. And that's all that we have for you today. Very good.